In a landmark ruling, the Supreme Court of India on July 10th ruled that divorced Muslim women are entitled to claim maintenance from their former husbands under Section 125 of the Code of Criminal Procedure, or the CrPC, affirming that a parallel remedy under this particular secular statutory provision would not be foreclosed by the enactment of the Muslim Women Protection of Rights on Divorce Act of 1986, which is a personal law or a religion-specific law. A bench of Justices B.V. Nagarathna and Justice Augustine Masih pronounced separate but concurring judgments upholding the rights of Muslim women after a Muslim man challenged a Telangana High Court direction to pay Rs 10,000 in interim maintenance to his former wife under Section 125 of the CrPC. He had contended that the maintenance claim in his case would instead be governed by the provisions of the 1986 Act. Hello and welcome to The Hindu. I'm Aratrika, and in this video we will delve into what the Supreme Court has said in its verdict, its significance, and what these two laws stipulate. But before we proceed, let us first understand what the law on maintenance is in India. Section 125 of the CrPC allows the grant of maintenance to destitute wives, children and parents if they are unable to take care of themselves financially. It stipulates that if any person having sufficient means neglects or refuses to maintain his wife, children or parents, then a court, upon proof of such neglect or refusal, can order such a person to pay a monthly amount for her maintenance. The explanation to this particular provision clarifies that a wife includes a woman who has been divorced by or has obtained divorce from but has not remarried. The provision, however, does not specify anything about the religion of the woman, which makes it a secular law. The amount of maintenance that a court can order differs from case-to-case basis and is generally dependent on factors such as the dependent's needs, the respondent's financial capacity, among others. Various states have, however, brought in region-specific amendments to put a cap on the amount of maintenance that a court of law can order. Now let's come to the 1986 Act, which provides a procedure for Muslim women to claim maintenance during divorce. Like I've mentioned, this act is a personal law or a religion-specific law. But before we proceed, let me also give a bit of a background, since this issue has been very political in the past. In 1985, the Supreme Court in the case Muhammad Ahmed Khan vs. Shah Banu Begum, popularly known as the Shah Banu case, the Supreme Court ruled that Section 125 of the CrPC applies to all citizens irrespective of their religions. This was in fact a landmark decision in India's constitutional history and involved crucial issues such as the intersection of religious practices and individual constitutional rights. The verdict was, however, perceived by many stakeholders to be an affront to Muslim personal laws. As a result, the 1986 Act was eventually passed by the Parliament, which essentially negated the Supreme Court's Shah Banu verdict. Section 3 of the 1986 Act guarantees the payment of maintenance to a divorced Muslim woman by her former husband only during the iddat period, a period usually of 3 months, which a woman must observe after the death of her husband or after she gets divorced before she can remarry. This maintenance amount should be equal to the amount of meher or dowry given to the wife at the time of a marriage or any time after that. After the enactment of the 1986 Act, various petitions were filed in the Supreme Court challenging its constitutional validity on the ground that it violated various fundamental rights. In 2001, in a judgment pronounced by the top court, the court clarified that the law is indeed constitutionally valid, but interpreted it to mean that a Muslim man is entitled to ensure that there is reasonable and fair provision for the future of his divorced wife, extending beyond the iddat period as well. However, subsequently, various high courts pronounced contradictory rulings on whether divorced Muslim women would be barred from filing applications under Section 125 CrPC after the enactment of the 1986 Act. Last week's verdict provided much needed clarity by unequivocally affirming that a claim under Section 125 of the CrPC is maintainable irrespective of the applicable personal laws of the parties. The top court in its verdict pointed out that Section 125 CrPC was introduced as a measure of social justice to protect women and children. A Muslim woman is entitled to claim maintenance both under Section 125 of the CrPC as well as Section 3 of the 1986 Act. It said that the option lies with the woman as to whether she's going to seek a remedy under both the laws or either of the two laws. In the verdict authored by Justice Nagarathna, the court said that the 1986 Act was enacted only to provide an additional remedy for Muslim women. She said that this is evident from the fact that while enacting the 1986 Act, Parliament did not simultaneously or any time thereafter create any bar for a divorced Muslim woman from claiming maintenance under Section 125 of the CrPC and thereby constrain her to proceed to make a claim only under the provisions of the 1986 Act. Neither is there any bar express or implied under the 1986 Act to the effect that a divorced Muslim woman cannot unilaterally seek maintenance under Section 125 of the CrPC. One cannot read Section 3 of the 1986 Act to restrict or diminish the right to maintenance of a divorced Muslim woman under Section 125 of the CrPC, and neither is it a substitute for the latter. Such an interpretation would be regressive, anti-divorced Muslim woman and contrary to Articles 14 and 15, Subclause 1 and Subclause 3, as well as Article 39, Subclause E of the Constitution of India. The judge also spoke about the vulnerabilities of married women who do not have an independent source of income or even have access to monetary resources in their own households. In fact, Justice Nagarathna also pointed out that maintenance is a facet of gender parity and is an enabler of equality and not charity. The court has also clarified that in a case where the husband has fulfilled his obligations under Section 3 of the 1986 Act, or as provided by customary or personal laws, the divorced Muslim woman can still subsequently invoke Section 125 of the CrPC on the ground that she is unable to maintain herself. If the husband then opposes such an application, he has to prove two things. First, his initial obligations under the relevant customary or personal laws are fulfilled by him, and second, that the wife in light of this is able to maintain herself. The court further clarified that in case it is determined that a reasonable amount of maintenance had already been given by the husband as per existing personal laws at the time of divorce, then the maintenance amount under Section 125 of the CrPC can be reduced accordingly. Another important observation from the ruling is that Muslim women who have been divorced through illegal methods such as triple talaq are also entitled to claim maintenance under Section 125 of the CrPC. The practice was declared unconstitutional by the Supreme Court in 2017 and later criminalized under the Muslim Women Protection of Rights on Marriage Act 2019. Section 5 of the 2019 Act talks about subsistence allowance and says that a married Muslim woman who has been given triple talaq or other instant talaq is entitled to receive subsistence allowance for her as well as her dependent children. The court clarified that in such a situation, the woman can seek relief under Section 5 of the 2019 Act or under Section 125 of the CrPC. The option here again lies with the concerned woman. This verdict has been hailed by various jurists to be a great example of how the court has used harmonious interpretation to expand the scope of rights and also to secularize the access to remedies. Thank you for watching. For more such videos, please subscribe to The Hindu.